So I think we can start now. Could I commence by welcoming everyone to this online seminar in the Monash University National Commercial Law Series, which is supported by the Federal Court of Australia, the Victorian Bar, and the Commercial Bar Association of Victoria. My name is Michael Wheelahan, and I'm a judge of the Federal Court of Australia, and I am the chair of the seminar. I will introduce tonight's speakers shortly. In 2005, the parliaments of the states and territories of Australia enacted largely uniform defamation legislation. Until then, the statutes in each state and territory of Australia relating to defamation were different. The New South Wales Defamation Act 1974 was sui generis. It was substantially different from the laws of the other states and territories, and it attracted much criticism for the complexity that it introduced. The main features of the 2005 uniform legislation were as follows. Firstly, to introduce pre-litigation steps, which will be the subject of discussion this evening. Secondly, to provide for statutory choice of law rules. Thirdly, to introduce 9 statutory defences on top of existing common law defences. Fourthly, to impose a qualified cap on damages for non-economic loss. And fifthly, to require that in cases tried by jury, judges and not the jury would assess damages. Tonight's seminar is concerned with the proposed amendments to the uniform defamation legislation. Those amendments have already been enacted by the New South Wales Parliament by the Defamation Amendment Act 2020, which received the royal assent on 11 August 2020 and is due to come into force on a day to be fixed by proclamation. We are very privileged to have 3 eminent and very experienced practitioners speak to us about the amendments. Our first speaker is Nick Pullen, who's a partner at HWL Ebsworth. He has spent an entire career practicing in media and communications. He's acted for broadcasters, book publishers, and newspapers. He's run a high number of high-profile cases to judgment, including Glare and the Herald and Weekly Times in 1992. In that case, Jeff Scher, whom Nick instructed, told the jury in opening in his usual understated way, "This is the most serious libel anyone could ever publish about any person anywhere in the world." More recently, Nick acted for the actor Geoffrey Rush in his claims against the Daily Telegraph in the federal court. Our second speaker is Georgina Schott QC, who is a member of the Victorian Bar. Georgina also has spent an entire career practicing in defamation, advising clients, and appearing for parties at trial. Gina has appeared in many landmark cases over the years, including recently appearing at trial for Bauer Media against the actor Rebel Wilson. Our third speaker is Justin Quill, who commenced practicing in media law as a young solicitor at Cause. His career developed to a high level very quickly, and he has devoted his practice exclusively to media law for 24 years. He provides advice to and acts for media companies across Australia, and he has recently joined the national law firm Thomson Geer as a partner. The proposed amendments to the Defamation Acts have many features, indeed too many features to mention tonight. Many of the changes to the law that we will not explore in detail include the introduction of what is in effect a single publication rule, the restatement of the statutory defence of contextual truth to cure anomalies that were identified in relation to the existing provision, and the reformulation of the cap on damages so that the cap is to operate now at the upper end of a range, and that an award of aggravated damages is now to be in addition to other damages for non-economic loss. Tonight we will focus on 3 proposed changes to the law. Firstly, changes to pre-litigation steps that are to be prescribed before a proceeding may be commenced, which Nick Pullen will principally address. Secondly, the introduction of serious harm as an element of the cause of action for defamation, which Georgina Schott will principally address. And thirdly, a new defence of public interest, which Justin Quill will address. There will be debate amongst the speakers on these topics. In broad terms, we will spend about 15 minutes on each of the 3 topics, leaving 10 minutes for questions. In relation to questions, there is a Q&A button at the bottom of the screen, which may be used to pose questions. If you would like a particular speaker to address a question, please nominate the speaker when posing the question, and also in framing the question, please identify who you are and where you are from. I now invite Nick Pullen to address the first topic.
Thank you, Your Honour. I'd just like a little leeway here, because just a small editorial with a bit of an overview of what I consider this new regime to be. Quite frankly, I think it's an abomination when it's considered against a paramount principle of access to justice. Even a cursory analysis will show that the individual will be open to constant prejudice when it comes to costs, emotional investment and time that will follow this new regime. I might sound a bit cynical here, but many of these changes are geared towards ensuring prospective plaintiffs are greeted with as much disincentive as possible to take proceedings. And the winners, I'll put them in quotation marks, are the so-called stakeholders of those who drafted this regime, I think ostensibly on behalf of representatives of the mass media. This is not striking the correct balance for free speech, as has been touted by the mass media. It is in fact, and will ultimately encourage more of the same when it comes to unbalanced and shoddy journalism that we are exposed to on a daily basis. This area of defamation should not be the plaything of procedural complexities that turns our civil laws into a Kafkaesque nightmare. The opportunity to make a real and meaningful change to defamation laws has been lost in this first round of amendments. And I think it mostly serves and reflects the misguided interests of mainstream media. Now, a good example of this is my topic, which is the concerns notice. After a publication, the first step in defamation proceedings is, at the moment, generally a concerns notice. Now, a typical situation is the phone will ring off the hook. A client will say, I have been pilloried. My life is now worth nothing. I have just been egregiously defamed, and I need to remedy this as soon as possible. I am suffering, my family is suffering, and my reputation is now down the toilet. I need to have something done about this straight away. What can you do? Well, right now, we can issue proceedings. Yes, there is a concerns notice regime, but that really is an issue to costs, and quite frankly, in the scheme of things, when things need to be done straight away, you can issue proceedings and show the world that you have taken not only this matter seriously, but starting to broadcast not just the egregious nature that has happened, but the falsity that you are trying to remedy as quickly as possible. But once this regime is introduced, the client will need to be told, oh, hang on, we can't actually do anything right now except issue a concerns notice, because the new regime will require, before we actually issue proceedings, to issue a concerns notice. That is a letter from the solicitor who will be outlining what is required in the new regime. Now, this is found in section 12A, and we'll just quickly go through what those requirements are. The requirement is that the notice has to be in writing. That's nothing new. Specifies the location of where the matter in question can be. Well, that's good. That's a new change that's come in. It must inform the publisher of the defamatory imputations that it considers that come from this material. These are known as the imputations of concern. We'll come back to that in a second. And informs the harm that the person considers to be serious harm as a result of this publication. And this is an issue that will be discussed at greater length later on. Now, that's all very fine, and I'll come back to that in a moment, but I'm still going to concentrate on the aggrieved plaintiff who wants to get something done straight away. Once we've done our concerns notice, that's all very good. Then I've got to not just ensure that, and I'll come back to this regime, especially in relation to the issue of imputations, provide a copy of this concerns notice to the publisher. And then if I'm going to issue proceedings, I have to wait for at least 28 days before proceedings can be issued. Now, in that time, the publisher can continue to generate the same articles or the same publications or other publications that are similar to what has already been published, which I don't think is quite satisfactory when it comes to access to justice. Now, I'm just talking about being able to get things on track, let alone the costs that are going to be involved with these new processes. Now, let's look at let's look a bit more closely in relation to the concerns notice. Now, especially the requirement for the defamatory imputations that are required to be articulated in the concerns notice. Why is it important? It is important because if we issue proceedings, we are not allowed to deviate from those defamatory imputations. In other words, once proceedings are issued, we are stuck with them. There can be slight variation, but that once again is going to be an issue that's going to be that can be and will, I'm sure, be litigated if mass media are involved in these proceedings. Now, what exactly is trying to be alleviated here? I don't know of any other laws, certainly in Australia, that require by legislation this regime when it comes to initiating proceedings. In other words, proceedings should be able to be issued and not be either hamstrung or put in a straitjacket when it comes to one of the most important parts of the defamation action are the imputations that arise. I have been with some of the greatest legal minds in Australia when it comes to evolving defamatory imputations arising from a publication. It's been quite rightly characterised as part science and part art form. I've had, as I say, some of the greatest legal minds for days agonising over whether or not they've got the imputations correct. So how is a solicitor supposed to provide quick and active, not just advice, but also action on behalf of a client whose reputation is going down the toilet, not to mention the incredible emotional stress that both that person and their family are going through. And the only access they have to remedy that is through defamation proceedings. When it comes to sending a message, not just to the publisher, but also the world at large. Now, not only that, I've got to also inform the prospective plaintiff that you've got to show some serious harm here. And we might not be able to show it straight away, but we'll get there. But the issue here is that that could be held to more interlocutory proceedings before we get to the final hearing. Defamation proceedings are some of the most expensive pieces of civil litigation an individual will ever find themselves in. It has layer upon layer of procedural complexities, and all this starts to do, and we haven't even issued proceedings, is begin that process whereby not just time, but also, just as importantly perhaps, costs are being spent at a great rate, because really the practitioner, whether it's the suburban solicitor or the commercial lawyer who has a plaintiff like this, will have to go to a barrister who knows what they're talking about in this regard to be able to get off the first step. So let's look timing on this. Oh, a week or so goes in relation to being able to get the concerns notice correct. A week or so after the publication. Okay, so we get the concerns notice to the publisher. we can't do anything. We cannot issue proceedings for another 28 days. So we're already into over a month, 5 to 6 weeks. Where's the access to justice to that? It has always been and should be an underlying principle when it comes to defamation proceedings, that these are heard as quickly as possible. There's a person suffering out there because of the damage to reputation. But here, and I kid you not, this is just the thin end of the wedge of this legislation. Here, there are road stops, speed humps, matters that will create more and more costs because of the procedural complexities that will deny access to justice to individuals. Corporations don't sue in defamation anymore. They're effectively gated because of the requirements for a corporation to be able to sue in defamation. It's individuals that are being affected here. Now, I mentioned very briefly about the offer of, the 28 days. The reason why there's a 28-day period is because you cannot issue proceedings until the offer of amends period has expired. Now that is now a 28-day period. The 28-day period begins once the publisher receives the concerns notice. Now, in that time, the publisher may request further and better particulars of those defamatory imputations. And once again, that can be used, I believe, by the publisher in very cynical ways of trying to stymie a litigant, a legitimate litigant in defamation proceedings. Because they may very well be, because of the costs already they're encountering, they may be put off by the paragraph that's been there, but wasn't there when concerns notices were compulsory, but it is now. Now quite relevant under 12A5, where if an aggrieved person who fails to provide a notice pursuant to, an answer or reasonable further particulars pursuant to that notice for further particulars, therefore the concerns notice is deemed to have not existed. No concerns notice, no issuing of proceedings. It follows that way. That's really all I've got to say about concerns notices at the moment, but certainly happy to take questions afterwards. Thank you.
All right, so just to remind everyone, there's a Q&A button at the bottom of the screen for the purposes of submitting questions. I'll now ask Georgina Schock to speak to us on the topic of the serious harm element that is proposed.
Thank you, Judge. I must say that in addressing the question of this reform, this proposed reform, I think a number of the criticisms that I would make of it are like those that Nick's just made about the concerns notice. I think this reform, which is introduced by a proposed new section 10A, is the most profound of the amendments proposed. And whilst it's said to be intended to overcome a perceived problem of a proliferation of trivial neighbourly disputes and backyard defamation claims, it's said to be addressed to those sorts of claims. In my view, this is going to have a profound effect on all plaintiffs in all defamation proceedings. What Section 10A does is to introduce a new element to the cause of action for defamation, and that is an element of actual serious harm to reputation. Those of you who know something about the law of defamation will know that the common law has always and does today presume damage to reputation if the words published are defamatory. That is, if they've got a tendency to injure somebody in their reputation, then that's all that need be established. A plaintiff doesn't have to go out and prove actual damage. In this regard, the common law has always distinguished between libels, where the mode of publication was permanent, and in the case of libel, there was this irrebuttable presumption of damage. But for slanders, where the publication was considered to be more transient, a plaintiff had to allege and prove special damage. There were some exceptions to that. They were words imputing criminal offences, words imputing a contagious disease, words tendering to injure a person in his or her office, calling, trade or profession, and words imputing unchastity to women. So that was a well-known distinction. When the 2005 amendments were made and we had the introduction throughout Australia of the Uniform Defamation Law, that distinction between libel and slander was abolished. And by Section 7, that was by Section 7 of our current Defamation Act in Victoria and the other acts throughout the country, by Section 7(2), the publication of defamatory matter of any kind is said to be actionable without proof of special damage. Now, of course, that relates to special damage, and that provision remains. But what one now needs to do is to prove that the publication of the defamatory matter about which a person sues has caused or is likely to cause serious harm to reputation. And by subsection 2 of Section 10A, if a proceeding is brought by an excluded corporation referred to in Section 9, and as Nick just said, corporations basically can't bring defamation proceedings anymore. They have to be an excluded corporation, and that means effectively a very small, there's a list of them under Section 9 of the Act, corporations with less than 10 employees or not-for-profits. But if a corporation of that kind wishes to bring a defamation proceeding, then it needs to establish that it's actually suffered or is likely to suffer serious financial loss. And so these matters are going to have to be part of the pleading, as we will see. And not only that, they have to be set out in the concerns notice, because they're also requirements of the concerns notice, as Nick has already outlined. So one will need to work out pretty quickly what actual harm has been caused or is likely to be caused. And many of you will immediately appreciate, for instance, if you're acting for a corporation, just how difficult that task would be. Whenever a corporation sues for damages in this area of the law anyway, that's a matter that usually requires expert evidence about the books of the account and the effect that it's had upon the corporation. Now, this new serious harm element for the cause of action is in fact very similar to provisions that were introduced into the were introduced by the Defamation Act 2013 in the United Kingdom. And so they've already been the subject of consideration by the Supreme Court of the United Kingdom in a case called Le Show and Independent Print Limited in 2019. And Lord Sumption, who gave the principal judgment with whom all the other members of the court agreed, confirmed that the effect of the amendment was to do away with that common law irrebuttable presumption that a defamatory publication causes damage to reputation. So there it is, it's gone, and well, once this amendment comes in, as it is likely to do, that presumption will be gone. And the impact, as I have said, will be profound. That's the first part of the proposed amendment. The second part of the proposed amendment are a number of subsections that deal with procedural matters for determining this threshold element. Now, and this, it seems to me, is going to also introduce complexity frankly, it's hard to see how it could be workable except in the clearest of cases. The first matter to note is that the Parliament has provided that it's the judicial officer rather than the jury in defamation proceedings that is to determine whether the serious harm element has been established. That is going to be the first difficulty because, of course, in order to determine whether defamatory matter has caused or is likely to cause serious harm, the first thing one needs to do is determine meaning. No examination of defamatory matter can occur without knowing what's the meaning of the words conveyed by the publication. And so if a judge is to determine that as a threshold matter, then that immediately sets up the possibility of inconsistent findings between the judge and the jury. Now, if a party wants this issue determined at a preliminary stage, then the court is directed to do so as soon as practicably possible. Of course, there are some matters that the court might take into account in determining that these issues must await trial. For instance, the cost implications for the parties, these are set out in one of the subsections, subsection 6. Cost implications for the parties, the resources available to the court at that time, and the extent to which establishing the serious harm element is linked to other issues for determination during the trial of the proceeding. It seems to me that that last matter, the extent to which it's linked to other issues for determination, is going to be the major hurdle, particularly when one considers that the first step has to be a determination of meaning. There are other difficulties that might arise as well, particularly with the intersection between this serious harm threshold and the contextual truth defence which these amendments retain. For instance, that defence is one where a defendant can say there are other imputations conveyed by the matter of which the plaintiff complains. Those imputations are true, and by reason of the truth of those imputations, the plaintiff's reputation is not further harmed because of the imputations upon which the plaintiff relies. So immediately one can see that the contextual truth defence is concerned with harm to reputation, and that's another aspect of a defence that might overlap with the serious harm element. Indeed, one might ask if a judge were to determine at a preliminary stage of a proceeding that the imputations had caused or were likely to cause serious harm, then one wonders what work is left for the contextual truth defence to do. Other difficulties with this, of course, is that to work out whether or not you're likely to suffer harm will require a plaintiff to know what is the extent of publication. Now, that's not something that a plaintiff necessarily does know, particularly in the case of an internet publication. It's a question that might require discovery. If it's internet publication, it might just require subpoenas to be issued. and against various internet service providers, against search engine operators. One just doesn't know. So at the very early stages of a proceeding, it's in my view going to be very difficult to properly particularise the serious harm. And the reason why I say it's going to have to be done up front is that as an element of the cause of action, those acting for plaintiffs are going to have to be able to say there's a proper basis for pleading, that there's a serious harm suffered or a likelihood of serious harm. These matters are meant to be set out in the concerns notice. And if you don't comply with those concerns notice requirements, you may not even be able to issue a proceeding. And finally, because there is provision in the proposed amendment for a judge to deal with this element on the papers if there are not adequate particulars pleaded, or if there are not adequate particulars in the pleading to establish serious harm. So this is a whole lot of work that's going to have to be done up front in the proceeding. And I just think that this amendment is, for all those reasons, going to be pretty unworkable.
Try that again. Thank you, Georgina. I'll now call upon Justin to address us on the defence of public interest.
Thanks very much, Your Honour, and thanks also to Nick and Gina for those comments. I must say, before I talk about the public interest defence, I probably don't tend to disagree with much that Gina said, but I'm hoping, although I haven't actually submitted my question on the chat group, I'm hoping that I'll get the chance to debate Nick about his comments on the concerns notice process, and that'll be no surprise, I'm sure, to Nick that I say that. In terms of this new defence of a publication on an issue of public concern, I might start by saying I'm generally an optimist, and so I'm going to be really try and be very optimistic about this. So I'm going to start with the positive, and then I'm going to move to what are some of my concerns and where I see some of the negatives about this particular defence, and in particular, not so much the defence, but the way in which the legislation is drafted, noting that we are moving almost certainly towards this being in effect in the not too distant future. I think it was actually passed before the Legislative Council here in Victoria late last night. I think I may be right about that. In any event, if I start with the positives, I've got one, and that is that the defence is in. This is a good development, in my view. Its purpose is to promote public interest journalism. And people might debate whether a particular piece of journalism is or is not in the public interest, and might debate what exactly is meant by public interest journalism. But I would have thought that really nobody would argue that that is not an appropriate aim to have, that we should be encouraging, supporting and enticing publishers into engaging in more appropriate public interest journalism. So that's the purpose. Now, whether it has that effect remains to be seen. But so that's where I start with, just that one positive. It's the fact that it exists, or that it's going to exist. Moving to two of my concerns, and I'm really only going to raise two concerns in relation to the legislation. Of course, this is a new defence here in Australia, or will be a new defence. So really, we can only get a proper analysis of it by looking to its counterpart, or the section in the UK Act, the 2013 Act from the UK that it's based on, and that's section 4. So we look to that for some guidance. And one of the things I've got to say, I think you know, the Australian legislators, I think, probably just thought they were a bit smarter than the UK ones, but I'm not sure that I agree. What they've done is they've added in a, so that the new defence is contained in section 29, capital A, and the first section, subsection, is very clear. It's a defence of the publication of defamatory matter if the defendant proves the matter concerns an issue of public interest and the defendant reasonably believes that the publication of the matter was in the public interest. Really simple, really clear. Juries or a judge sitting alone would be able to consider that and determine it. The second subsection is just that a court must take into account all of the circumstances in the case. Again, very clear. We then get into the muddying of the waters. This is a new subsection that is in the proposed Australian legislation that doesn't exist in the UK Act, and it creates this subsection 3 that sets out a whole series of factors. I think there's 9 factors, A to I, including, I'll just read 2 or 3 of them: the seriousness of the defamatory imputation carried, the extent to which the matter published distinguishes between suspicions, allegations, and proven facts, the extent to which the matter published relates to the performance of the public functions or activities of the person, and it goes on. So those sort of matters. Now, my concern is that we are going to get into a situation where you have in court, when this defence is being tested, a checkbox situations, and juries or judges will go through, and of course every barrister will think, I've got to go through and tick the box, or if they're the plaintiff, try and get across in as many boxes as I can. It doesn't seem to me that's the appropriate way to do things. Now, true it is, some will say the original legislation in the UK was based on the Reynolds decision, Reynolds and Times newspapers, the 2001 decision. Now, that decision set out a number of factors, and the very original version of this defence in the UK included the factors. It had a checkbox in there, but ultimately, the legislator in the UK decided it wasn't the appropriate way to go. And reading from the Minister of State for Justice explaining the change, the dropping of the factors at the time, he said, although we do not believe that the courts would apply the list of factors based on those in Reynolds as a checklist, we've responded to strongly expressed concerns that the use of a list may not be likely to lead in practice to litigants and practitioners adopting a risk-averse approach and gathering detailed evidence on all the factors in case the court will ultimately consider them relevant. On balance, we consider that it is preferable for there to be greater flexibility that a statutory list might provide. And I've got to say, I agree entirely. You've got the UK legislator steps ahead of us, years ahead of us, having considered these issues and decided that checkbox approach, that list approach, shouldn't be applied. And I've got to say, I agree entirely with that. I think simplicity is better. The second of the 2 negatives I would raise is, again, a difference between the Australian legislation and the UK legislation. And it is really the non-inclusion this time of a subsection from the UK legislation, subsection 4, to their equivalent. Section 4 is their equivalent. So the subsection 4.4 included in it provision for consideration of editorial judgment. The subsection, the relevant subsection included in determining whether it was reasonable for the defendant to believe that publishing the statement complained of was in the public interest, the court must make such allowance for editorial judgment as it considers appropriate. Now, that's not included in the Australian legislation. In my submission, in my view, it should be. Thought I was appearing in court for a moment there with a judge and a court emblem behind me, Your Honour. But in my view, that should be included in there, and it hasn't been included. I've got to say, I think it's got to do with the view of and I'd say this clearly, unfairly held view of the Australian media compared to the views held by the judiciary in the UK of the Australian media. I'd point to a couple of cases in the UK within the last decade, Guardian News and against Ahmed, Flood's case, Flood and Times newspapers. The comments there where the judges, and I've just read a couple of quick quotes from those decisions. The judges are recognising that editors know best how to present material in a way that will interest the readers of their practical publication and so help them absorb the information. A requirement to report in some austere, abstract or devoid of much of its human interest could well mean that the report would not read and inform and the information would not be passed on. Ultimately, such an approach could threaten the viability of newspapers. There is this, and I won't bother reading the second quote from Flood, but there is this acceptance that things don't have to be written in the way lawyers would write them. And with all due respect to all the lawyers on this Zoom call, we're not going to write in the same way, and our writing would probably be useful for bedtime reading for people who might be insomniacs to put them to sleep. We're not going to be able to write in such a way as to get the information across. I look at court reporters and I see the way they take a long day's court reporting and put it in a succinct fashion. I'm always marvelled at it. That acceptance of the right for the media to present things in their way is just not prevalent here within the legal fraternity. I mean, at the bar and also in the judiciary. And it seems to me that's, in my view, one of the main reasons why that subsection 4 was not included and should have been included. I think it's a real miss. This talk tonight is headed much needed reform or missed opportunity, and I'd say that non-inclusion of that subsection is a real missed opportunity. The verdict, look, it's wait and see. It'll really, I guess, it's over to the judiciary now to see how this is implemented and considered and applied. So I'm reserving my decision on whether I'm overly happy with it. I'm happy it's in, but it could be in a few years' time. I'm feeling like it hasn't made any difference, and that's my fear, that it won't really make much of a practical difference. But hopefully I'm wrong about that, and the aim of promoting public interest journalism will actually be borne out by the inclusion of this defence.
Thank you very much, Justin. Before I go to questions, I just want to open up some discussion amongst the panel. Nick, do you want to say anything about the defence of public interest?
No, look, I certainly applaud the intention behind it. I can't see it, though, actually making any real difference concerning its effectiveness. Having seen, I can't say previous iterations, but similar qualified privilege defences that have been used, I really want to. I really applaud the initiative behind the investigative journalism, if they get it right. However, if there's, I don't believe just simply a belief, and I know it goes further than that, but nevertheless a belief in the ability to found reputational damage on simply a belief is sufficient enough, and I don't think the courts will follow along those lines either. The same way they haven't, whether it's been Section 30 or Section 22 of the old New South Wales Defamation Act.
And from a practical perspective, how do you think the serious harm threshold will operate?
From a practical perspective, I think where there has been an agreed, well, call egregious, a very serious defamation, I don't think there should be a problem for a plaintiff ultimately getting to a final hearing and having it heard. I have a major objection to the way that why there is so much confusion about it, because it will be used by defendants as another hoop to jump through. More costs, more time, more angst, because of its lack of clarity in relation to where it must come within in the course of proceedings. That's my main objection to it. I think it will serve very well getting rid of what we call the backyard disputes, which I do think needs to be dealt with, and perhaps that's the way of dealing with it. But once again, adding to the complexity, as I say, and adding to the cost of proceedings, it could have been worded a hell of a lot better, is what it comes down to.
Now, Gina, you've acted in at least a few cases involving investigative journalism on both sides. What do you say about the proposed offence of public interest?
Well, I think you have to remember that if you're running a defence like this, it's usually because you've published something that you can't prove is true, or your justification defence has failed, or it's not just opinion based on facts that are proved to be true. So defences like this are there when the media has published something defamatory that can't be proved to be true. And that's why I think it's important that the media be held to high standards of journalism. Now, that's what these various matters set out in subsection 3 of the proposed amendment are there to cover. And I think Justin's right to say it would be a pity if they were dealt with as a tick box. But I think the proposed amendment does seek to overcome that by setting out in subsection 4 that one is not required to take into account every of those factors, and they don't limit the matters that can be taken into account. So they just are there as a reminder to the court and then to the parties that these are the sorts of things that ought to be considered. And I think they're important things. I mean, I think good journalists would take all of those matters into account anyway in preparing a piece of investigative journalism.
Now, Justin, do you agree with the issues that Nick identified in relation to the provisions relating to concerns notices?
Look, I don't. The one thing I did agree with Nick on was when he said it is one of the most expensive types of litigation that anyone's going to get involved in, and it's the procedural complexities of it are extreme. I agree entirely with that. That's where the agreement ends, and that is also where I say that's exactly why we need these things. Ultimately,
so when you're acting for a plaintiff, do you think that these provisions will erect barriers or unnecessary barriers for your client?
I think what they'll do is make me focus on what the real issue is going to be in the case, and that is going to make the defendant focus on exactly the same thing. If you're going to have discussion, if you're going to try and avoid the incredibly expensive, incredibly procedurally complex litigation, it's about getting a meeting of minds in terms of what's being argued here. And ultimately, what I really heard from Nick was, well, we want to complain about one thing, but be able to sue about another. Now, what's the problem with saying, well, if you're going to sue, you should first try and resolve it? That's ultimately what this legislation, this part of the legislation is designed to do, is designed to bring the parties together to see if it could be resolved before it goes to court. And because once you start, we all know what it's like. Once you start and you're off to the races in that sense, there's no coming back. So that's why I just don't think it's an issue. Now, I might say if you're really upset about it, how you could change it, the legislation is to take out the prohibition on suing on different imputations and insert a provision or a sub-paragraph that says, if you do that, so if you complain about one imputation but sue on another imputation, you're entitled to do it, but then the offer of amends process starts again. And the proceeding can run at the same time as the offer of amends process. So that gets over entirely the hurdle that Nick was concerned about. You know, he wants swift action to no doubt send a message to defendant and perhaps public that the plaintiff is aggrieved. It allows that to occur, but it also allows the offer of amends process to actually operate. To have a situation where you can complain on one imputation and then wait your 28 days and then issue on something else and say, well, the offer of amends process is, you've lost your opportunity. It doesn't make sense to me. And to be honest with you, I'm surprised that people are upset about this. I get the idea about wanting to move quicker, but this is about bringing people to the table and hopefully avoiding expensive litigation that all people regret, except the lawyers. The lawyers will win in that situation.
Now we've got two questions. The first question I'm going to put to Georgina, and it's from Grant Holly from Holly Nethercote Lawyers. And Grant asks, this is in relation to section 10A and the serious harm element of the cause of action. How widely do you think the courts will interpret the phrase likely to cause in relation to serious harm?
Oh, well, Lord Sumption in the Supreme Court has already considered that. And he said that what that meant was probable future harm. And he also said that it was a question of fact. So in other words, you couldn't simply rely on the tendency of the words, but just with actual harm, that is past harm, you had to establish it as a matter of fact. So if you had a hearing early on, for instance, the court might want to hear evidence about extent of publication. It might want to hear evidence from a plaintiff about the sorts of people who read the material, his relation or her relationship with them, and why it was likely that publication to those people of these particular imputations is likely to cause him actual reputational damage. I think that's the way it will be interpreted, and I think that Lord Sumption's judgment will be followed here in Australia.
Thank you, Georgina. The second of two questions we have is from David Gilbertson QC from the Victorian Bar. He has a question about the components of the public interest offence in the proposed section 29 capital A of the amended Act. And David asks as follows, to what extent do you anticipate that the factors which a court can take into account under the new section 29A3, and these are the factors that you, Justin, referred to a few minutes ago, to what extent will they assist the court in determining whether the defence is being made out? And I might put that question first to Justin and then ask Nick to comment.
Well, look, I mean, I have to accept that they're all relevant factors. I don't really quibble so much with the factors. Some of them are quite important. The subsection 3F, I think, is quite a good way of dealing with the source situation, where you have a journalist who says the information was based on a confidential source. So it's not the case, as it is with some of these other similar defences, where if the journalist is relying on a source and they have to say, well, I'm not going to reveal the source, you effectively can't rely on the defence. This sets up a different regime whereby the court can consider, can allow the source to remain confidential, but consider the way in which the reason for which they have to remain confidential. So I've got to say, I think I don't have a problem so much with the factors. It's more the checkbox nature of them. Will they assist the court, which is Gilbert's question. Sorry, Mr. Gilbertson QC's question. I think, I mean, I'm not sure they get you to the nub of the question is what's in the public interest. You know, that's a very difficult question for a court to answer. So, look, I don't have any particular problem with any of the factors. I'm worried about the checkbox nature, and yeah, that's probably, hopefully that answers the question.
Nick?
Yes. Look, I take what you say, Justin, about the checkbox nature of that. I mean, as Georgina has, but I must say, I'm very sceptical at how this will be treated by the courts in relation to what is a matter of public interest, but the defendant reasonably believing the publication of the matter. What is that belief founded on? And I think there's a bit of a giveaway in subsection 3A, where right at the top of the checklist is the seriousness of the defamatory imputation. In other words, the more serious it's going to be, the more I think the defendant will be put to the high jump in relation to the honest belief. I would not be surprised if it starts getting towards, well, you know, not necessarily a justification or truth defence, that is the evidence that's required there, but not far from it. That's my take on how this section is probably going to be applied.
Can I say something in relation to that? It seems to me that this defence will come for consideration there already being either a presumption that the imputation is false or a justification defence having failed. And so that consideration of the seriousness of the defamatory imputation, if it's extremely serious and there's an inability to prove its truth, then a lot more is going to be required of the media before a court or a jury will be satisfied that it was in the public interest to publish that particular imputation. I think there'll be a lot of weighing up of these factors in coming to a view about whether it was in the public interest to proceed with the publication.
Jenna, I think the critical, I don't disagree with what you just said there, but I think the critical thing here is this is not a reasonableness test. And that's why I am cautiously optimistic about the defence. Too many times, the Section 30 defence is, the qualified privilege defence is treated, it should be treated as, okay, it only arises or it only becomes relevant if the truth defence fails, as you very correctly point out. And too often it feels to me like, oh, once the truth defence fails, well, how could you possibly succeed on reasonableness if what you published is not true? Well, what do we have the defence then? If what we're essentially saying there is the only defence really is truth, maybe opinion, but the only defence is really truth. Here, the critical thing here, and the reason, as I say, I'm optimistic about it, and the reason why I applauded at the idea of it, is that the defendant has to reasonably believe it. Now, of course, it can't be that they hear a rumour and publish. That's not going to stack up. But when you look at all of the factors, and it might be a confidential source in a particular government department or whatever it might be, when you look at all these factors, if it's ultimately decided, well, had this been true, it was in the public interest, and it was reasonable to believe it was true. Once we start saying, but it wasn't true, so well, it can't have been reasonable to believe it. Well, then the defence we may as well throw out. Then the only defence we're talking about is truth, and this defence is absolutely toothless. So we've got to be really careful, I think, to not sort of include in this sort of defence a notion of truth. And I should say, I'm not suggesting you were saying that at all, but I think that's really important, that this defence should not require the imputations to be true. They should require it to be reasonable that you believe them to be true.
Well, I mean, my point is simply that the defence proceeds because they're not true. So we should therefore require, particularly if it's a very serious imputation, we should require the editor or the journalist or whoever's decision it is to have done their utmost to check it, knowing that they might not be able to prove it true, but because it's such a serious matter, it's gone to print anyway. And so that's why I think it's important to have these various factors set out, because they do hold the media to account. And if the media wants that defence, they'll have to hold themselves to those high standards. And that's good for all of us. It's good for the media, and it's good for us as well, for the public.
Just to add to that, that's my recollection of one of the rationale for the criteria set out in the Reynolds case, that the House of Lords said it wasn't for the media to determine what was reasonable, it's for the court.
Yes. But you look at their belief and determine whether that belief was reasonable under this defence, as opposed to the publication being reasonable. That's that's a big change, and that's why I keep saying I'm cautiously optimistic, and I hope, and it seems to me that that's appropriate, that's a good defence, an appropriate defence. My concerns that I raised with it were only about the way in which it was implemented, right, really.
Well, can I thank each of our three speakers tonight? I'd like to thank each of Nick, Georgina and Justin for their time, and we've certainly had some healthy and lively debate about the issues that have been thrown up by these proposed amendments to the legislation. I'd also like to thank the Monash team who have assisted in organising this seminar, Heather Treverson, Janice Hugo and Jennifer Hill, who have done a lot of work in the background to bring this presentation to bear tonight. So that completes the seminar, and I wish everyone a good evening.